Welcome to the deep dive. Imagine this. A pretty standard lawsuit over unpaid bills, maybe, but then the defense hits back claiming massive fraud.
Okay, happens all the time.
Right, but here's the kicker. The key evidence, the smoking gun needed to prove that fraud, is locked up tight, protected by the highest court, all because of two words: trade secret.
No, that makes it interesting. You're talking about that big 2007 Philippine Supreme Court case? Chiarnups 1x2835. Right. Air Philippines versus Pennswell.
Exactly. It wasn't just about the money owed, though that was part of it. It really became this fundamental fight between the right to get evidence discovery and a company's right to protect its core formula, its, competitive edge.
Precisely. And our goal here is to dig into why the court made that call. Why deny Air Philippines access to what they claimed was essential proof, this detailed list of chemical ingredients, especially when they were alleging like 500,000 pesos in fraud?
Yeah, it's a really fascinating intersection of intellectual property law and, well, the basic search for truth in a legal dispute.
It all kicked off pretty simply, though. Pennswell, they make industrial chemicals, lubricants, that sort of thing. They sued Air Philippines because, well, Air Philippines hadn't paid its bill.
Yeah.
About $450,000 plus interest.
Okay, straightforward enough. But Air Philippines didn't just roll over. They countersued immediately.
Right. They said, hold on, we're the ones who've been wronged here. They alleged that in earlier deals, Pennswell had actually defrauded them out of even more money, closer to $592,000.
Wow. What was the alleged scam?
The claim was pretty specific. Air Philippines said Pennswell sold them identical products, chemically speaking, but slapped different labels on them. Different names, different prices, effectively charging them twice for the same stuff.
Wow. So like selling Super Grease A and Megalube X when they're actually the exact same formula?
That was exactly the allegation. They even listed pairs they suspected were identical. Things like contact grease versus connector grease, or thixotropic grease versus something called dielectric strength protective coating.
Okay, I see. If they're identical, you'd only need one. So to prove this, Air Philippines needed to see the recipes, essentially.
Exactly. So they went the legal route, filed a motion to compel, asked the trial court, the RTC, to order Pennswell to hand over those detailed ingredient lists for the specific pairs they named.
Makes sense. They wanted a neutral third party to compare them, right?
Yeah, they even suggested who should do it. PIPAC, the Philippine Institute of Pure and Applied Chemistry, have them run the analysis.
And this is where it gets twisty. The trial court initially said yes.
It did. March 2004, the RTC granted the motion, said basically, Pennswell, you need to provide the chemical components for comparison.
Okay, that sounds like progress for Air Philippines, finally getting the evidence.
Not so fast. Pennswell immediately filed for reconsideration. Their argument: these aren't just ingredients, they're confidential, they're proprietary. They are a trade secret.
The magic words.
And they worked. Just a few months later, June 2004, the RTC did a complete 180, reversed itself.
Whoa. So the judge changed their mind entirely, just based on the trade secret claim?
It seems so. The RTC, on second thought, agreed the chemical components were privileged information. And that's the core legal defense kicking in.
How so?
Well, the rules of court, the rules that govern how you get evidence like this discovery, they have specific exceptions, and privileged information is one of them. Trade secrets fall under that umbrella.
So for you listening, this is a key point. Even if you think evidence is absolutely vital for your case, if it's legally privileged like a trade secret or maybe conversations with your lawyer, the court generally can't force the other side to reveal it.
And it's not just some minor rule. This protection has constitutional backing in the Philippines. Jurisprudence, cases like Chavez v. PCDG, clearly state that trade secrets are recognized limits on the public's right to information. They put them up there with like national security matters or confidential bank records. It's serious stuff.
Okay, so if it's that protected, what exactly is a trade secret legally? Pennswell couldn't just label anything secret, could they? What's the test?
Right, there's a specific definition the court used. It's basically a plan, a process, a formula, maybe a tool or mechanism that's known only to the owner and, key employees who need to know.
And crucially, it's not patented.
Usually not patented, but used commercially. And here's the most important part. It has to give the owner a real demonstrable advantage over competitors who don't have that information.
So it's really about the competitive edge. That's the value the law is protecting here.
Absolutely. The court looked specifically at Pennswell's situation. They found that this formula wasn't just mixed up randomly. It was the result of Pennswell putting in Efforts, skills, research, and resources.
Okay, so they invested in developing it.
Exactly. The court said these ingredients constitute the very fabric of respondents' production and business. Forcing them to reveal it, the court reasoned, would basically cripple respondents' business and put them at a huge disadvantage. That potential harm was seen as greater.
But I have to ask, isn't there a risk here? If a company did commit fraud, couldn't they just hide behind the trade secret label to avoid getting caught? It feels like it could shield bad behavior.
That's a really valid concern, and the courts know it's a balancing act. There's precedent, like the Copeland case, saying the determination of a trade secret needs a substantial factual basis. It has to pass judicial scrutiny. Employers can't just call anything a trade secret willy-nilly.
So the court has to be convinced it's legit.
Right. And in this specific case, the court seemed convinced that these specialized aircraft lubricants were genuinely proprietary and valuable, not just some generic mix.
Okay, so the trade secret claim held up. Did Air Philippines have any other arguments, any other way to try and force disclosure?
They did try. They tried to argue that other laws already required Pennswell to disclose the ingredients, which they hoped would override the trade secret protection.
Clever. What laws did they point to?
Well, first they tried the Consumer Act, RA 7394. You know, the law that often requires ingredients or materials to be listed on labels for consumer goods.
Right, to protect everyday shoppers.
Exactly. But the Supreme Court shot that down pretty quickly. They said Pennswell's products, specialized lubricants for aircraft engines and propellers, are not consumer products.
Because they aren't sold to regular folks for personal use.
Precisely. The Act defines consumer products as things for personal, family, household, or maybe agricultural use. Industrial aircraft chemicals just don't fit that definition at all. It shows a clear difference in transparency rules between business-to-consumer and business-to-business sales.
Okay, so the Consumer Act was out. What was their second attempt?
Even more of a long shot, maybe. They point to the special law on counterfeit drugs, RA 8203.
Drugs. How did they connect lubricants to drugs?
Their argument was likely focused on the disclosure requirements within that law, hoping the principle might apply. But the court wasn't buying it. Logically, aircraft grease is not a drug.
Yeah, that seems pretty obvious.
The court just pointed to the definition. Drugs are for treating, preventing, or diagnosing disease in humans or animals. Lubricants clearly aren't that. So both attempts to use other laws failed.
It really sounds like the legal system has built a strong wall around these kinds of secrets. You mentioned the court even brought up things like the penal code punishing employees who leak secrets.
Yes, and even the Toxic Substances Act. It paints a picture of a very consistent state policy. Protect industrial property, protect innovation, protect that competitive edge.
But going back to my earlier point about potential injustice, is this protection absolute? What if revealing the secret is the only way to prevent a massive injustice?
That's the crucial check and balance. The privilege is strong, but not absolute. The court acknowledged that disclosure can be compelled if it is truly indispensable for doing justice. That's the ultimate threshold.
Indispensable, meaning without this specific piece of evidence, the whole case falls apart. Justice can't be served.
Essentially, yes. Is it so critical that fairness demands overriding the privilege?
And in this case, a lawsuit about collecting money owed, even with the fraud allegation, the court decided revealing the formula was not indispensable.
That was the final decision. The Supreme Court said, look, revealing the formula wasn't absolutely necessary for Air Philippines to defend itself in a collection suit.
Even with the fraud claim, how could they defend against that without proving the products were identical?
The court suggested they still had other legal arguments available. They could argue breach of contract, maybe misrepresentation based on the labels, or defects under sales law. These arguments wouldn't necessarily require revealing the exact chemical breakdown. It might be harder, sure, but not impossible.
So the court saw other paths, even if they weren't the easiest path for Air Philippines.
Right. And when they weighed Air Philippines' need for this specific evidence against the potential harm to Pennswell's business if its core secret was revealed.
The secret won.
The secret won. The court explicitly said the greater interest of justice ought to favor respondent as the holder of trade secrets. Their reasoning was that trade secrets get value from being secret, so they deserve greater protection from discovery. Protecting that economic value, that competitive engine, took priority here. The petition was denied. End of the road for getting that formula.
Wow. So the big takeaway here is pretty stark, isn't it? The highest court basically said protecting a company's proprietary formula, its economic backbone, often outweighs a litigant's desire for the easiest or most direct proof, especially if other legal defenses, however imperfect, still exist.
It's a powerful precedent. It underscores how much legal weight is given to the investment, the time, money, effort that goes into creating something unique and commercially valuable. That secrecy itself has immense value in the eyes of the law.
Which brings us to a really interesting final thought for you, the listener.
Yeah, think about this. In this case, the perceived value of keeping Pennswell's formula secret, protecting its competitive advantage, was deemed more important than resolving a dispute worth about $500,000. So in a world increasingly pushing for corporate transparency, especially around things like algorithms or chemical contents, how does this strong legal protection for competitive advantage square with that push, particularly when there are allegations of wrongdoing or significant public interest? It really highlights the tension between protecting innovation and ensuring accountability.